Namaskar, Sat Sri Akal, Adab, and good morning. This is my 296th video, and this will be covering PP Act under Order 1, Rule 8, when the notice is either withdrawn or is it kept in a cyanidized situation. So, what are the consequences when such a doing is done by an estate officer under the Public Premises PP Act 1971? He actually is stated to withdraw the proceedings. Now, after doing such an act, whether the rights of the parties are primarily governed by principles of procedure of law and statutory schemes, which emphasizes that the jurisdiction of the estate officer is limited to initiating and conducting proceedings, and that the withdrawal of such proceeding does not automatically extinguish the rights or claims of the parties. The parties retain the right to pursue their civil claims through other legal remedies, including civil courts, unless they are strictly barred by law. So we need to get into these nitty-gritties. In a lot of cases, which I know in the last 5 years, where PP Act notices have been kept under cyanidized situation or they have been withdrawn, and this entire research on this withdrawal grew when I was handling a case of Merit Bungalow. From there, I saw that the resumption notice was issued and the PP Act notice was issued simultaneously, and without giving due procedural or hearing, the same notice was withdrawn. The party was not aware, neither was I aware. So the party went in a different format of writs. The state officer handed over the premises to the station commander. So there we started digging into these laws, and I have more than about 100 plus judgments on PP Act starting from 1958 when the first 57 PP Act was initiated, and some proceedings even earlier from 1930 where the Britishers were initiating these. So what does the withdrawal of a PP Act proceedings by the state officer, what does it initiate, or how does it continue even after this doing? So the jurisdiction of the civil court remains intact for adjudicating the rights title or claims which are not expressively barred by the PP Act or other relevant statutes. The procedural nature of the PP proceedings and the role of a state officer is of an administrative authority imply that a withdrawal of an administrative act, not a final determination of rights. So friends, please, there is a small understanding in this speaking of the law. It says what is an estate officer and what are his duties. Everything what he does is of a dutiable procedure as an administrative act. So he is not operating as a judge or a statutory body or a tribunal. So he is working as an administrative officer who's making an inquiry. So PP Act, whether to be initiated on your bungalow or your property in bazaar area, is a matter of question, which I simply say that no PP Act can be issued to any bungalow or resident in the cantonments. There are some bungalow owners. Recently, somebody approached me from Sagar cantonment. It was a notice under 51B. So the bungalow owner did not understand the consequences that once a PP Act is proceeded or initiated on his premises, it would deem to be a public premises. So friends, please remember, I've been saying since last 10-15 years, whether a notice in PP Act is issued for 4, Section 5, Section 7, 8, none, because as a whole, I believe PP Act cannot be applied when the ownership or the title to the suit property is disputed. If they want to initiate construction cases, let them go under the Cantonment Act, Section 185. If they want to initiate a recovery suit, let them go under a recovery suit of the CPC. Here also the department very smartly initiates in a different format. They'll file a challan in the courts and then they'll ask you to do the recovery. See, everywhere the government has a liberty. So when we say we are one, we are not one. Now, Supreme Court in 2023, in a judgment very clearly of SS Con Builders Private Limited, said that the proceedings are primarily inquisitorial and aimed at eviction or possession related determinations, not necessarily adjudicating ownership or proprietary rights. So what I just said meant that PP Act or an estate officer has no right to decide your ownership or proprietorship or the title in the suit land. So if that is disputable, then how is he initiating PP Act on you? He cannot. But what has been happening for the last some years? We people very coolly, very initiatively, because of our financial constraints, for our educational constraints, for unfortunately our advocates' knowledge constraints on the Cantonment Act and the laws, we fall into this trap and we let the PP Act be initiated on us. So the legal consequences of an estate officer withdrawing proceedings under the PP Act is that the specific administrative process ceases. However, as clarified in legal interpretation, such withdrawal does not automatically bar the aggrieved party from pursuing their rights through other legal channels. And particular, it is civil courts. The withdrawal is an administrative act, not a judgment on the substantive right of the parties involved. So what is after or post withdrawal? Do parties retain their rights? Yes, they do retain their rights. They can go to the civil court, establish their or contest their ownership, title or other rights concerning the property. This very judgment of SS Construction Builds Private Limited 2023 clearly says this. We can initiate independent proceedings under the civil court, seek remedies such as declaration, rights, damages, injunctions, unaffected withdrawals of proceedings unless there exhibits a specific bar to do this. So the legal principle in judicial precedents, the legal principle, the civil court is not ousted in cases where PP proceedings are withdrawn. In support of by judicial decisions, emphasizing, now here the court says, where are these judicial decisions? 1958 Supreme Court very clearly said, it recognizes that withdrawal of proceedings does not amount to a final adjudication of rights, and civil courts remain competent to decide such issues. So where is the exceptions and limitations? If the law explicitly provides that the withdrawal of proceeding is final and conclusive on the rights of the parties, which generally is not in the case of PP Act, because I explained in the earlier part, an estate officer cannot decide ownership. He cannot decide title to the land. So please understand, So the available remedies are once again on a case-to-case basis. We need to understand the law. We need to understand the evidence in hand of the property. This is where I tell everybody, please collect your land documents. These are going to be very important for you. You must have sale deeds prior to these 4 cut dates which I've been mentioning. 1938, 1912, 1899 and 1924 Cantonment Act. So where all these things are written, recommendations by the law are very clear. Parties should utilize the same what I just said, either go to civil courts, file their ownerships. They should preserve all this evidence and record. This is what the judgment said. So that their claim towards anything what they are asking in a subsequent civil litigation is a matter of evidence. Legal counsels should carefully analyze the specific circumstances and provisions applicable onto the particular case or to case. So withdrawal proceedings have been explained. Whether this principle of proceedings can be challenged, property is in possession of a receiver or under a statutory specific statutory rule. In 1958, in the Kanhaiya Lal judgment, it was very clearly briefed. So what are the main legal aspects now? When a state officer is withdrawing his unauthorized Occupants Act 1971, whether in under 4, 5, 7 or 8, so the legal rights remain. Proceedings, the procedural safeguards available to the parties is very clearly that this withdrawal does not automatically extinguish his rights. So what do? We need to go to the court or we need to file a review. It's very simple, but just have your evidence. And whether you had made a reply to that PP Act in an elaborated manner, asked for a hearing, whether those hearings were accorded to you or not. Sometimes what happens is the proceeding goes, but the order does not come out. So is it that when the conclusive evidence is led by either side, the state officer's department, because he's the boss of his own department. So let's say if the DO issues you a notice, so his DO office will lead its evidence, you will lead your evidence in the state court. It's a proper judicial court. But the state officer does not have powers of a judicial officer. He's an administrative officer. So his withdrawal or not does not make a difference. Now the process has to be in principles of natural justice. Where is it written? Mumbai International Airport Private Limited versus Golden Chariot Airport 2010. Friends, you can read these judgments. Steel Authority of India Limited versus Life Insurance Corporation 1997. So these all judgments speak of all this. They clarify what is a state officer as an inquiry officer, not a court or a tribunal, and that no appeal lies against interim orders passed by these. This indicates that the proceedings before the state officer are of an investigative nature and administrative. And the withdrawal of those proceedings are generally that the state officer has completed his inquiry and he does not find an order to be pronounced on it. Now one may understand it. Let's say there is an officer, he conducts through a PP Act, allows the department, allows you to lead evidences, and on the conclusion he finds that the PP Act which was initiated by the DO or the CO was not right. So what he does, he doesn't pronounce an order, he withdraws or sanitizes that order. So that is not a judgment. Now what you have to do is, you have to go to the court. Either you go to the writ or you go in for a review or you go in for an appeal. So those are all to be decided as per your evidence, as per your documents. Now what are the effects of withdrawal or proceedings? The documents do not state the right of the parties after withdrawal. However, by analogy and principle of administrative law, the withdrawal can be challenged if it is arbitrary, malified, and violates principles of natural justice. I just mentioned you the 2010 Mumbai International Airport judgment, where this entire finding was given that when a state officer withdraws, what can he do? Legal rights of parties on withdrawal, proceedings. These rights very clearly include whether can I challenge them, whether the possibility of filing a writ petition for a judicial review if the withdrawal is alleged to be illegal or unjustified. So these judgments very clearly give you the right to challenge this withdrawal or sine die. So friends, I think we have been very clear. I can quote another 10 judgments. I have a list of, after this Meerut case, more than about 125 judgments starting from 1957 and of the Privy Council during the British era. During their period, what was the state officer and what was the then so-called PP Act or a public premises. They never bought in an act like this. It was bought by the Indian government in 1957. So here we have to even understand there are some limitations. If the law provides a mechanism to challenge withdrawal, parties must follow that. The procedural safeguards depends on whether the withdrawal was made by following due process. So then it becomes a kind of an order itself. Like he's made you lead evidence, he's made the department lead evidence. So there is a scope of a judicial review, which again is very limited. Procedural fairness and constitutional principles, and on the merits of the case you can go. So what do the law recommend us? Parties should carefully examine the grounds and the manner of withdrawal. If they believe it was unlawful or unjust, they can file a writ petition or challenge the withdrawal. Generally, I would advise to ensure that the withdrawal was made after proper procedure and on an adequate hearing opportunity in the court of state officer. So these principles drive down when the legal counsel has been representing himself in a state officer's court. So means that natural justice was absolutely kept in bay, and you can file it in the principles of violation of natural justice. References were given on these 2-3 judgments which I quoted above, and I believe people will understand why I've been saying this for the last 10-15 years. It's not very easy. Last 2017, when the first Delhi residents took a stay on their lease money, which was a recovery suit under the PP Act, you have to understand these notices are in a sine die or a withdrawal situation. We've gone to the court in a writ format prior to an order being pronounced, and we've challenged the very notice there. So what gradually would mean is that there is no withdrawal, but there is a writ, and that writ has said that let the government make a policy, like what had just happened in Bahuguna's case in Allahabad. What have they won? They have won nothing. SLP has been filed. STR making was never challenged. Procedural anomalies were never challenged. Whether the department was in a position to lease you out the property on a particular rent amount was never challenged. Can the government resume your lease was never challenged. So what is challenged? I don't understand. There are some legal luminaries who talk to me and they don't understand. We have not challenged the ownership. We've not challenged the rights of the government to give us lease in 1922 or 28 or 1899 under the codes or 1912. Did the government was actually the owner of this old grant at that time, which was actually under section 12 converted into a lease. Wake up, friends. We are all revenue free grants. After 1899, we were given leases. And I must put a full stop to my this video by saying that there is a case going on of Gymkhana Club Delhi, which is a perpetual lease. Those people don't understand that whether Luton's Delhi, including the present Delhi Cantt, was one part. They have to understand that when that lease was made, it was made under the Delhi Cantonment Act. So this is how the whole show goes. Thank you. Good day.